Ladies and gentlemen, dear honorable guest, colleague Professor Dupuy, dear colleagues, senior and younger ones, it's a great pleasure and honor for me to welcome you in this prestigious event, a highly interesting and relevant lecture of Professor Dupuy on international law as a common heritage for mankind. And by this opportunity, let me pay tribute to three parameters: the man, the subject matter, and the bonds, the relations. The man, of course, about Professor Dupuy, my colleague Professor Passerzi, is about to speak you thoroughly about his contribution, the depth, and the whole of his whole work and his whole contribution in science. Nevertheless, I'd like to stay to the fact that Professor Dupuy incarnates a family tradition. He's the son of a glorious expert of international law, René Jean Dupuy. So, in a way of speaking, he is himself a sort of legal heritage by his own respect. And indeed, it's one thing to speak of legal heritage, another thing is to experience it. Now, the subject matter. Of course, I'm not an expert of international public international law. I'm simply a humble civil lawyer. Nevertheless, permit me to say that yes, usually the continental national lawyers criticize international law since it lacks enforceability. Yet, on the other hand, the ultimate desideratum for national, continental perhaps, law is its positivity, its verifiability, and its stability. Therefrom, several legal schools are stemming. For instance, the historical school argues that positivity lies in the fact of the implementation of law. Nevertheless, we are interested in law not when the law is implemented, but when the law is infringed. The Begriff jurisprudence focuses on law's logical dimension. Nevertheless, things with law are not so ideal. And at the end of the day, we all know that positivity of continental national law lies in the fact that it is written. There out stems the criticism of Staatsanwalt Julius Kirchmann, that one word of the legislator and then thousands of legal pages go to trash can, zu Makulatur. This is our positivity. On the other hand, your positivity, by way of contrast, the international law's positivity, is much more, not internal, of course, nothing is internal, but much more stable. Either the positivity of customary international law, or even the positivity of treaties, because treaties are changed, of course, less often than laws, unluckily. So, indeed, in this respect, I might dare to feel that international law stipulates a common heritage, legal heritage for mankind. And last but not least, the bonds, the relations, since, of course, human beings are the most relational ones. And indeed, this prestigious event, apart from enriching us in knowledges about public international law, it stipulates, it broadens, it deepens our relations, our bonds, the bonds between Public International Law, Athens Public International Law Center, and by a way of reflection, Athens Law Faculty, on the one hand, and the Dupuy tradition, delegation, scholars, friends whom we belong already to. Once more, many congratulations in advance, and perhaps I might ask you for your understanding for leaving a little bit earlier due to my other academic/administrative duties. Thank you very much.
Good evening, ladies and gentlemen, Professor Dupuy, dear colleagues, dear students, and all those who are watching us from streaming. I want to welcome everyone to the Nikolaos Politis Memorial Lecture, which this year we're very proud to have with us a very distinguished figure and a great friend of Greece. So the Athens Public International Law Center, the institution within the law faculty that does international law with all my colleagues, we organize these events, especially these lectures, in the name of someone who was a Greek scholar, academic and diplomat, and had ties both with this university, but also with your first university professor. So thank you all. I would also like to thank the European Society of International Law. This is going to be, and is right now, streamed online from ESIL, and it will be an ESIL lecture. It will also be, the video will also be available on the website of the European Society of International Law, so I want to thank them for this. And I think it will be the first lecture to be initiating this series of this new generation. Dear colleagues, we all know Pierre-Marie Dupuy, but I have to explain a few things to the younger students here. Professor Pierre-Marie Dupuy is an emeritus professor of the University of Paris II, Panthéon-Assas, and is a member of the Institut de Droit International. During his career, he was also professor for many years at the European Institute in Florence and the Graduate Institute of International and Development Studies in Geneva. Now, Professor Dupuy is one of the founding members of the European Society of International Law, conceived in Florence many years ago, and he is also, was, and continues to be, I think, member of the Board of Editors in an advisory capacity now of the European Journal of International Law. I could name other journals as well. He was also editor-in-chief of the French Revue Générale de Droit International Public. Professor Dupuy has acted also as counsel in numerous proceedings before international courts and tribunals, in particular in the International Court of Justice. His most recent pleadings were during the request for an advisory opinion on climate change, for which we're all expecting the court's advisory opinion. He has also acted as arbitrator in both as member and as chair of arbitral tribunals in arbitration proceedings and investment under the ICC, the International Chamber of Commerce, and ICSID. So for those of you who are freaks, investment freaks, he's also an expert in that. He is a generalist of international law. I will probably upload his long biography and his bibliography for our LLM students. I see some of you here, to your great discontent. But I have to say, among other things, first of all, of course, one of the most famous manuals of international law, the Manuel de droit international public, which is now in its 17th edition, accompanied by the Grand Texte de droit international public, by, of course, all the work he has done on international responsibility, le fait générateur dans la responsabilité internationale des États, la responsabilité internationale des États pour les dommages causés par les activités technologiques industrielles. I think this was his thesis at a time when nobody was talking about these things. So perhaps today you might think that, you know, all this is, oh, yes. But this was, you know, in the 70s when this was really, really uncharted territory. Now, for today, and I'm sorry not to evoke all of your work, sir, but for today, I want to refer to one other opus magnus, his Cours Général in the Hague Academy on the unity of the international legal order. The course was delivered in French. He had previously, of course, delivered a special course a few years before that. But I will stop at that one because there, Professor Dupuy, in this general course, made a plea for the unity of the international legal order at a time when everybody was talking about fragmentation. This is 2000, 2001, if I'm not mistaken. And, you know, it was a plea that was really a loud one, I think. Perhaps it persuaded some of his colleagues who were thinking fragmentation to think otherwise as well. A few weeks ago, Professor Dupuy published a very short blog in ESIL Talk on international law as a common heritage of mankind. And, you know, the title seemed huge for just a small, a short blog. But I understood, and probably he will explain to us today, how the way he has come back to the unity of the international legal order to look at it or revisit it at a time where, as you know, what is happening right now in the international legal order is something probably totally different. Monsieur le professeur, nous souhaitons le bienvenu. Excusez-moi d'avoir pris le temps, mais votre biographie est immense. Donc, c'est un plaisir, mes collègues et moi, de vous accueillir ici. Merci beaucoup.
I come back to the place where a teacher likes to be, in front of people who remain critical, thanks God, but who listen and are ready to exchange views, and this is the very core of our function, so to say. If you allow me, I will first say a few words in French because of Nicolas Politis, who had a special dimension as a French professor. He was a French professor. He had the agrégation de droit. Et donc, je voudrais dire quelques mots pour dire que c'est un honneur tout particulier pour moi de parler dans le cadre des cours qui lui rendent hommage. C'était un grand professeur, c'était un grand diplomate aussi, bien sûr, chacun le sait. Je ne veux pas réduire sa dimension à la dimension académique, mais il pouvait s'habiller comme moi sur la photo que Madame Bazarcis a eu la gentillesse de reproduire, ou a pris le risque de reproduire, c'est-à-dire il était agrégé de droit des universités, des facultés françaises, et il a beaucoup contribué à faire passer, notamment en France, qui est quand même longtemps resté, et qui est dans une certaine mesure, heureusement encore, la patrie du positivisme le plus strict, cette idée il faut aussi compter avec la morale internationale. Je ne veux pas être trop long en français, je voudrais juste rajouter que il y a de très nombreux liens personnels entre les professeurs de cette faculté et la mienne. Je ne vais pas tous les citer, mais pratiquement plusieurs professeurs les plus éminents de cette faculté ont fait leurs études à Paris, à la faculté de droit de Paris et à Paris 2. Et il y a eu une succession comme ça, et une tradition, là aussi, une sorte d'héritage commun. As you just said, dear colleague, I produced, perhaps I should say committed, a very short paper in the ESIL talk a few weeks ago, which was not technical, but which perhaps considered that we had to react, if not to resist, to an attempt made by a person who own, of course, respect, the present President of the United States, but his declarations and a number of his recent initiatives within the first 100 days of his presidency have raised a series of questions and perhaps even created some difficulty, in particular in the framework of the institutions devoted to multilateral relations and cooperation. I don't want to speak too much of President Trump, because we still don't know at this stage how his presidency will evaluate, and I must respectfully recognize that he has done his best so far without results for achieving peace in Europe between Russia and Ukraine. He has taken a view of the extreme difficulty of the task, which needs much more than 1 or even 100 days. But he has also, as I just mentioned, considered that some of the most essential institutions, international institutions, starting with the World Health Organization and the World Trade Organization, are not that important, and that the US could withdraw their participation. And more curiously, he has manifested that in a series of his initiatives, he simply does not take into account what is exactly the situation of the international rule of law. So once again, I don't want to conclude in a most too definitive way, but we are so far worried, and I decided, perhaps in a surprising way, to name my very small paper and this conference International Law as the common heritage of mankind, because I considered that it is our common heritage, that we are, for all of us, one way or the other, dependent on respect for the international rule of law, and that we as teachers, as international lawyers in general, and I shall come back on that point, we have a duty to defend the very, not only the very notion, but the very existence of international in the place where we are, which is only the one of students. We are all students of international law. I'm still one. It's a way, of course, to make me younger than what I am. And we have our task to defend our heritage. And this is basically what I shall speak of. In the first part, I will very briefly refer back to what I have already evoked and which you know from the careful reading of your papers. And in the second part, which will be perhaps more important, I will focus on international as a common heritage. On the first part, I would perhaps replace the situation left to international law by President Trump within a more general ambit, which is that of I would say not much importance paid to the law in general. In that respect, he is coming to the desire of a number of very powerful leaders of American technology who simply want to deregulate the activity of new technologies, including the development of so-called intelligence, artificial intelligence, which is a very worrying subject. And as you have seen, a number of cases are pending to attack a number of decrees which have been adopted by the president without paying much care to the Constitution of the United States, which is another illustration of the fact that not only the international rule of law, but law in itself is not that important. And I think we must be very careful with that, because it is more or less an idea which is also growing within some national movements, within some countries, saying, after all, the judge is not that important. He is very often creating difficulties to the efficiency of the action of the executive. And this development of the idea that efficiency does mean the putting of the judge aside is, I think, a very dangerous one, because what is at stake is the respect of the rule of law internally and internationally. Now, if I focus on the way in which international has been so far treated by the President of the United States, I must recognize that he does not, it seems, consider to be very important respect for the sovereign equality of states, since he wants to make America not only great again, but over the other states, and to make sure that that the U.S. will remain in that position. And one of the reasons I could develop that, but this is a bit outside the scope of my lecture tonight, one of the reasons of the Trumpism, so to say, is the fear of China. The fear to see that perhaps within a few period of time, the U.S. will not anymore count as the great power. Now, you have all seen, to go back to the international dimension, how he considers that multilateralism is not the best way to deal with international issues and international conflicts, because what counts is dealing with the other part. But dealing on which respect and on which basis, we still don't know exactly. And this is a bit a problem. If, of course, negotiation is a deal, and international negotiation is part of the means of settlement of disputes, Article 33 of the UN Charter. But still, I'm not sure that he first refers to that when he speaks of the art of dealing, of which he considers himself to be a master. Not much respect for the sovereign equality of state, not much respect for international obligation, may they be customary or conventional. You have seen, for instance, the way he is referring, or the way he's not referring to the very famous trilateral agreement between the US, Canada, and Mexico in terms of protection of investments. He simply wants to put it aside. Not a very important consideration for the obligation to cooperate. Not a very important importance accorded to the right of people to self-determination. The right of people to self-determination, of which the International Court of Justice itself, and I will come back on that later, considered that it belongs to imperative, peremptory norms of international law. He does not consider, I think, I'm afraid, that the prohibition of the use of force is of crucial importance, as he even considers that one of the ways to take control of Greenland would be a possible use of force, which is extremely surprising considering that Greenland is a country which is under, one must be careful, under the international control of Denmark, a member of NATO, and so far the US are still a member of NATO. Well, not much consideration for armed conflict and humanitarian law, and that goes back to the respect for self-determination, because the three of them deal, I'm sorry to say it, with the present situation in Gaza, as it has been established after the horrible crimes committed by Hamas, which, of course, for themselves must be punished. But the situation in Gaza has been created by the present government of Israel, and the proposal made by President Trump to make kind of a Côte d'Azur of Gaza is quite surprising, because Gaza is a place where the Palestinian population is based and should be respected. And he does not, of course, refer anymore to the two-state solution, which is the one proposed by a largest majority of state members of the UN and by the UN itself. When I entitle this presentation Common Heritage, of course, I took out of the law of the sea this notion without anticipating on the fact that a few days ago, not more than 3 weeks, President Trump decided that parts of the deep sea should be mined, should be explored, to do some mining of the deep sea resources without taking into account that in principles, not only on a conventional basis, if I have time to explain that, I shall come back on that, not only on a purely conventional basis, the deep sea is the common heritage of mankind, because the wealth it contains should be exploited in the benefit of the whole of humanity. And this is, of course, also what I think of international law as such. I'll come back on that. Now, I could go on with the list of the principles and rules which very much seem to be ignored by the President. But so far, I shall notice that all of the rules which I so far mentioned do belong to a specific category of norms, peremptory norms of international law, that can be discussed for some of them, certainly not for self-determination, certainly not for the interdiction of recourse to force, in particular for acquiring new territories, and certainly not for the fundamental principles of human rights and of humanitarian law. The court took position on that since 2006, when it finally decided to refer explicitly to peremptory norms of international law, which had been launched by Article 53 of the Vienna Convention of the Law Treaties. Now, this is where the old professor that I am will refer back to his theory. An old professor which comes back to his old theory. I shall be short. La faccio corta, would I say in Italian. On the year 2000, I had the privilege, and I was at that time still a young professor, rather young professor of international law, to teach the general course, which for 1 out of 2 is still taught in French. So French can be at some point an interesting investment in that respect. Not only French, and I could myself go on teaching in several other languages, but French has perhaps a special role, and the last time I played it before the International Court of Justice, I did it in French. Well, by the way, if you want to have a very small resume of the content of my lecture, you can go to the Cambridge Journal of International Law, June 2020, and you will find it in English. My idea is quite simple. Unity of international law based not only on one principle, but of two. Formal unity and substantial unity. Formal unity, which is the unity of the forms. Since millenaries, not centuries, millenaries, I insist on that, the way how to negotiate a treaty, which is an instrument of the deal at the international level, the ways how to negotiate a treaty are basically the same. the same as the ones there were, for instance, in 1275 before Christus, between Ramses II and Hattusili, the emperor of the Hittites. I saw the treaty, and it was a treaty as we are used to them right now. Unity, formal unity, because the way how to create treaty is the same. As far as customary international law, I agree there has been quite a large evolution of the process to create international customary law, non-written law. But still, an evolution, but not a revolution in that respect. And in that respect also, the codification of the law of treaties on their customary basis was not that difficult, and it was an important task which was displayed by the International Law Commission, as you know. But there is now a new kind of unity which is substantial in essence, which, in other terms, deals not with the way how to build up international norms, but which deal with the content of the norm. And a number of very classical colleagues, eminent colleagues of international law, including my former teacher, Professor Prosper Weil, had very many difficulties to accept that there are some substantial principles which cannot be derogated. But by the way, if you cannot derogate them, this is a formal criterion. It's a formal criterion. And you cannot do it. So there are formal criteria for identifying substantial principles, a number of which are listed down, for instance, in Article 14 of the Covenant on Civil Human Rights. Which means that there is a connection, complex connection between formal unity and material unity. And by the way, that as far as human rights are concerned, there are a number of them which cannot be derogated. And it's my pleasure and my honor to speak in front of the former president of the European Court of Human Rights, which has devoted so much energy and authority to look to human rights as really the basis, certainly for European law, but also for international law as such, and the references of the Court of the European Human Court of Human Rights to international are extremely large, numerous, and precise when they refer to the international rule of law. Even outside the European Covenant, they do it in a very precise and reliable way. So those two kinds of unity are very important, as you kindly referred to it earlier, to demonstrate that there is no fragmentation of international. By the way, I don't want to be an ugly European lawyer, but this idea of fragmentation, even if it has its roots in some work of a special rapporteur, Mr. Ripagan, uh, before the International Court of Justice, the International Law Commission, received very much encouragement in the American doctrine some 20 years ago. And I was at the same time visiting professor in some of the American universities. I was never in agreement with that. There is no fragmentation. There is general international law, which is extremely important for every domain of international law, and there are covenants, or treaties or agreements, which deal specifically with one field or the other. And if I come back to that now, it is because precisely the material unity of international law, which points once again to substantial principles, all of which do not deal with human rights, but some of them also with the rights of the state, in particular the right of equality of state, or the obligation not to have recourse to force, principles of which you immediately identify that they are taken out of provisions of, and the first provisions of the UN Charter. It is because precisely what is at stake with the present position or statements or initiatives of the current president of the US is that his attitude, his behavior, in a large way, put an emphasis on the fact that those principles should not be considered as important or even as existing, since it does not even take them into account for making proposals. Confer the transformation of the Gaza Strip into a very nice holiday territory for rich people. We have to react to that. We cannot leave that without protest. Who are we to do that? Once again, as I said earlier, we're just small individuals, the common feature of which is that we are, for all of us, interested in international law. We devote much of our time, and my colleagues and myself, most of our life, to this discipline because it is of common importance for the international community to which we belong. So we have to protest. And how to do that? That will be part of my second and last consideration in this presentation. What is the role of the doctrine, and how can scholars, researchers, students of international law contribute to the safeguard of international law as a common heritage? I include students, perhaps students who already know quite well or very well the discipline and who are engaged in doctorates, masters, and so on. But every international lawyer is concerned. We should contribute to demonstrate that, yes, indeed, contrary to what could be concluded from the behavior of Mr. Trump, there is still an international legal order, and that its importance and its safeguard are important for the whole of the community to which we belong. I think there are two ways to do that. The first is a rather classical one. We have to go on doing our task, our job. Professors by teaching international law, analyzing in articles and statements and lectures the content of the international rule of law. And there is also a larger dimension of the role of the doctrine of the scholar or the international lists in general. The first one I shall not develop, but I would like perhaps to insist very much on the fact, by giving two concrete examples, that technical analysis of the law may have a very political dimension. So that is part of the challenge, confronted to hot problems, which raise including political problems. And it is for us to find the right balance, because we have to respect the diversity of political opinions. But still, as international lawyers, we have to defend the law. Two examples, within the classical ambit of the task of the scholars. The first one is, I mentioned it earlier, the question whether the US, for instance, are still bound by the qualification of deep sea mining, or deep sea as common heritage of mankind. Are they or not? Well, there are arguments to say they are not. They don't belong to the parties to the 1982 Convention on the Law of the Sea. And the very reason why they are not a party to that convention is that they did not want to be linked by the provisions of this convention, which clearly state that the deep sea should be exploited within the framework of a precise legal regime. Yes, but a special agreement was negotiated during the further 10 years, the last decade, the first decade after the adoption of the 82 Convention, precisely on the issue of how to modify, develop, make better, according to the American vision, the regime of deep sea exploitation. The US, under the presidency first of Richard Nixon and then of the further presidents, decided that, yes, indeed, they would consider that the deep sea is a common heritage. They did not challenge that. On the contrary, they said, yes, it is a challenge, but we want it to be organized in a different way. And when the agreement on that part was adopted, which was aimed at being substituted to the part of the 82 Convention which dealt with the same issue, the US signed the convention, the new convention. They did not ratify, but they signed it. And they even took part in the first session of the special body, of which they were not yet a member, which is empowered with the way how to organize this deep sea exploitation. So you cannot say that there was a persistent objection by the US to the qualification, which was further qualified as customary, of the deep sea as part of the common heritage. This is important. This is quite technical. I could develop it. But it is the right time for coming back on that subject and explain it. I could give another example, which is also illustrated by the ESIL blogs. By the way, I'm not anymore a member of the board of editors of the European Journal, but I'm still very interested in the journal, which is the question how to deal, and once again, you know, a very technical, precise, but hard problem, how to deal with the permanent occupation of Gaza by one country. One country which was already qualified by the International Court of Justice in 2004 of an occupying country, and two eminent authors, Georges Abissab and Marcelo Cohen, have pointed yesterday in the very last issue of the blog, of the ESIL blog, to that question, and it is very interesting. I don't want to take the time to get into it, to see how they develop the argument that humanitarian law, of which is part, of course, the notion of occupying power, is not anymore the most appropriate notion, taking into consideration the length of the occupation of Gaza by Israel. It's an important question, a question of which, as you know, is the International Court of Justice itself, both on the advisory and the compulsory competence, contentious competence of the ICJ, so it is very important. But as I said, there is perhaps a new dimension of the role of us international lawyers, which is not that easy. I've tried it several times, and I must not be very good at that. I failed at getting some short articles published by the French journal Le Monde, which found them probably too technical. That is one of the difficulties. We have to address the public opinion, to tell them, look, this is a question of international law, quite technical, but it is important for us, but also for you. Because human rights are our common heritage. And if you discuss, even within your own family, with a number of well-minded people, a good number of them have no real idea of the fact that their national law, the law under which they are and on which depends depend their liberty, their freedom. This part of the law is indeed not only national but international, which means that when there are violations of basic principles of human rights in particular, their own rights are at stake, and that we all, for all of us, have had to be very careful to respect the rule of law, including its international dimension. You can do that. You can do that when speaking with your friends, when writing articles, when you are already a scholar, or when you are writing your PhD. The problem, of course, is that, as we do right now, when we meet together, we are all in agreement that the international rule of law is very important. Yes, of course. We are in the room where this is being taught. The difficulty is that we have also, not to convince, but to demonstrate, to show to our friends, but not colleagues, those who don't know the rule of law, that they also, for themselves, depend on it, although they are not specialized in this field. And that is very important, because what is at stake here, and you can say that what I shall say right now has a political dimension. I recognize it. What is at stake is very much connected with the defense of democracy. It is not in Athens that I have to develop too much the fact that there was a link between Solon and Pericles and Cleisthenes, and that the creation of new laws against the chaos, to defeat the chaos, was necessary for creating the first elements of democracy, with all the difficulties which belong to it, how to identify who are those who can participate in the democracy. Your ancestors began that so long time before anyone. So I don't want to develop that too much. I would perhaps still say how I am proud and privileged to recall this link between law, international law, and democracy here at some feet of the Acropolis. And this made me think of what André Malraux, the great author, and also the president, the minister at that time of culture of France, said here in 1959, when he came to Athens for the inauguration of the Sons et Lumières, the Enlightenment. Is once again a concept with several meanings of the Parthenon and the Acropolis. And André Malraux, he was feared with nothing. He was a great resistant, and he had been a great fighter, and so he made ancient Greece speak. And I suppose that he spoke first of all of Cleisthenes and Pericles. And he made them say, I shall read it first in French and then I translate it. So it is ancient Greek, but embodied by one of his heroes, let's say Pericles. J'ai cherché la vérité et j'ai trouvé la justice et la liberté. J'ai inventé l'indépendance de l'art et de l'esprit. J'ai dressé pour la première fois en face de ces dieux l'homme prosterné partout depuis 4 millénaires, et du même coup, je l'ai dressé en face du despote, which could be translated in this way. I sought truth and I found justice and freedom. I invented the independence of art and the mind. For the first time, I set man, who had been prostrated everywhere for 4 millennia, face to face with his gods. And at that time, I set him up to face the despot. So, of course, it was the emphatic way of Malraux to speak of it, but it was a way to, once again, point to the link between the rule of law, democracy, and the defense of our liberties, which constitute, by essence, our common heritage. And I thank you very much for having me.
Vous attendez peut-être qu'on vous pose des questions, je sais
C'est
pas.
comme vous voulez. Absolument.
So I'm not sure that if there's anyone who would like to.
No, but I'm ready to stop here.
Good. Make a question, have a question or a comment after this. Thank you very much. Professor Sicilianos, please.
D'abord, permettez-moi de vous remercier infiniment au nom des collègues ici présents pour cette démonstration extrêmement éloquente et avec laquelle nous souscrivons, je crois, parfaitement. I have a question concerning yesterday's article by our esteemed colleagues Josa Bissab and Marcello Cohen.
Yeah.
They are saying in substance that we should not, if I understood them correctly, we should not apply humanitarian law and the part of the Fourth Geneva Convention on occupation on those territories where the occupation exceeds some limits which they do not precise. The situation existed in Nagorno-Karabakh up until recently.
Exactly.
It exists always in northern Cyprus and in other places in the world. So especially because it exists in northern Cyprus, we are very, very interested in this way of thinking. Can we say that Turkey is not an occupying power? Is it what we mean by this article? I must confess that I read it with great interest yesterday, but I would like to reflect a bit more upon that.
Yeah, okay.
And of course, they are saying that the quintessence of their thesis is not to extend the privileges of the occupying power to Israel, but to replace the rules of the Fourth Geneva Convention by human rights rules, which are more demanding, let us say. And so it is in the privilege, in order to better protect the population. But I would like your analysis a little bit of this idea, taking into account what that means for an average Greek and, of course, for a Cypriot who has been for many, many years acquainted with the idea that Turkey is the occupying power there. Thank you so much again.
Thank you very much for this question. And to tell you everything, I had a phone conversation with Marcello Cohen after I had sent a mail to him and to Georges immediately after reading their blog, precisely because I wanted to know a bit more about their position. Because I agree with you, But I think it is the demonstration of the interest of their blog, of their text, that it can be discussed, and there are pros and contras. And you know Georges and Marcelo, and you know that they are absolutely open-minded and ready to discuss it. But I think you perfectly recalled the situation, and it is. I didn't think at that time, which proves that we arrived with my wife only yesterday afternoon in Greece, so I had no time to recuperate the vision, which can, of course, be considered as so important for Greece, that of Cyprus, yes. I think, if I may answer, because Marcelo, we had no time for discussing it thoroughly, but I think Marcelo would probably say, like Georges, both laws are applicable, and the fact that you may refer to human rights law does not necessarily means that you renounce to invoking also, when it is convenient, humanitarian law, which, by the way, is a situation, and correct me if I'm wrong, which is also to be found in some of the decision of the court you chaired, where precisely you did not hesitate, you or your predecessors. I'm referring to a case which dealt already in 2006, I think, with this horrible Chechnya war from part of Russia, at the time when Russia was still a member of the convention, the Human Rights Convention. The two of them can, of course, are still at the disposal of lawyers for finding and building up the best position. Perhaps Marcelo and Georges wanted to send a signal to the court, because they know that the court is right now considering the situation of Gaza on the advisory and on the contentious sides and dimensions. And perhaps they wanted, but I don't speak for them, to demonstrate, after all, don't be too focused on a humanitarian law, which still makes it possible for the occupying territory, occupying power, to take some initiatives in order to safeguard the security, if one may speak of security of the population in the Gaza Strip right now. And they perhaps wanted to send a signal saying, but by the way, general international law, including fundamental principles of human rights, offer a possibility. That is, I think, the way one could at best interpret their position. But I came to the same interrogation as yours, and the fact that we had the same reaction, which effectively was first of surprise, at least I think demonstrates that they made an interesting proposal. Yeah.
Aujourd'hui, you have issued a call to resist So I'm picking up your call of resistance and I'm moving on to organize the movement. And the next question, of course, is this. If international law is in fact a common heritage of mankind, I would go with that, no questions asked. If in fact we have built in those 3 generations of peace and security and affluence a network of rules upon which we have created a community of interests and principles, wouldn't be the correct approach, and perhaps even the only approach, to just set aside whomever is actually in breach of those rules and just simply move on with the rest of us? I'm referring to the fact that in spite of headlines and whatnot, we see a very definitive movement among several states and several parts of the world trying to come up with networks, with new corridors, with new arrangements, regional or mega-regional markets, all kinds of things, in effect, bypassing the US. And I was particularly struck, I was talking about that earlier today, by the fact that, for instance, within international organizations, the OECD comes to mind, we see effectively the member states, in spite of the challenges to their budget, sort of saying, okay, we proceed to the extent possible. And we just curtail operations if the money is not there, and we try and figure out whether there's more money coming out of that. So is resistance, in essence, persistence? That's my question. So thank you so much.
Well, I thank you for your question. I mean, we should recognize that one of the qualities of President Trump as a person is flexibility, and that at some point he's able to not necessarily change his mind, but to adapt his mind. He's currently demonstrating that in the economic and commercial field. And perhaps he can also do that as far as the international rule of law is concerned. And by the way, the US, and it is a very positive element, have tried or are still trying, I hope, to help in the achievement of a peaceful settlement of the Ukraine situation. But they are trying also to renegotiate, and that's very interesting, with Iran. Although they denounced, as you know, even President Trump himself, you're right, denounced the agreement on the limitation of Iran so that they don't get to the atomic bomb. So in a way, President Trump recognizes that the best way, the most happy end for a deal, to speak like he does, is a treaty. And of course, we could say that is contradictory with what you said he does with treaties like the NAFTA or his successor. Yes, but once again, we have to recognize that President Trump is a most pragmatic person. He demonstrated it in his career, and it could be the case that he comes concretely to recognize that, after all, international rules do exist and are to be used. He could, to speak in the way I do, take out of the formal part of unity, how to make up treaties or how to recognize that a norm is customary, he could find practical instruments for achieving his goals, which I think he is aware of the fact that whatever the case may be, he has to count with the international society, let's say, of states. And let's hope. But still, we have, I think, to maintain. When I say to resist, of course, I don't want to show up aggressively a red flag, but to insist of the fact that we are all concerned, and we should not consider that we can purely remain within our ivory tower. That's what I mean.
Thank you very much, dear Professor, Sir Professor, pour cette lecture. You referred to the new position of the United States regarding deep seabed mining, and which of course is not something new, because back in the 80s, and not only the United States, also the Soviet Union at that time, Germany and other Western countries were contrary to the concept of common heritage of mankind and to the whole emergence of a collective regime, of international regime, of administering the seabed resources. But now it re-emerges with sound, I can say like that. My question is the following. If we take this into consideration, but also how Israel treated the whole Gaza issue, and at the same time how Russia reacted against Ukraine, and of course the new spirit, if I'm permitted to say like that, of US diplomacy under the Trump administration. Could we say that in a world that we were accustomed to believe that international law have brought international cooperation and multilateralism, now we are facing a rebirth of a strong unilateralism in international relations? I would like to have your opinion on that.
One can say that, but I remember of a colloquium we had at the beginning of the life of the European Journal during still the 90s, which took place in Ann Arbor, Michigan University, where I had been at least 2 times visiting professor. And we organized that with my good friend Antonio Cassese, with Bruno Zema, with Joseph Weiler, and others. We organized that because we found that it was necessary. And at that time, we said that we had to defend multilateralism against unilateralism. And at that time, the name of the president of the US was Bill Clinton, which means that there is a tendency, and in a way, once again, one could understand that because of the power of the US and because also of the fact that they played a key role, if not the key role, for the creation of the new international legal order right after 1945. So there is a trend which is, I would say, linked with the dimension of the US. I think that, of course, there is a kind of provocation in President Trump's statements. But once again, we may perhaps hope that in his mind, some provocations are aimed at creating new situations. And one should recognize that at some point, very difficult issues need the creation of new conditions. So in that respect, I am not totally opposed to some of the initiatives of the Trump administration. Let's see. My only point is that we should be very careful with the way how they proceed, and we should be very careful that they do take into account, when trying to solve the most difficult situations, they take into account the international rule of law. That's it. But I think we still have more than 3 years of Trump administration, so we can be helpful, perhaps, but hopeful also. Thank you.
I think it's good that we should end on a hopeful note, and I would like to invite all of you to, first of all, extend a warm thanks and gratitude and applause to our guest. And please, everyone, you can join us for refreshments and ask further questions to Professor Dupuy right outside this hall.